If you're an employee in California and you're also a union member, you have two distinct sets of workplace rights that apply to you and can potentially protect you. You have your rights under the law by virtue of you being an employee in California, and you also have your rights under the CBA, which is a collective bargaining agreement by virtue of you being a union member. And collective bargaining agreement is the agreement or a contract between your union and the employer. These are two separate sets of rights, and while there are quite a few differences between these two sets, the most important differences that you need to know in the context of employment termination are these. The law, federal law or California law, is what protects you from unlawful discrimination, unlawful retaliation, and unlawful harassment. CBA, the collective bargaining agreement, is what provides its members with all kinds of benefits, wages, vacation, insurance, and all kinds of other benefits. But in the context of termination, it usually limits the employer's ability to terminate an employee unless there is just cause. In other words, there has to be a serious reason enough to terminate an employee, or a lesser discipline such as warning, suspension, or something less serious than termination should be imposed. And that's only under CBA, and that's what distinguishes the rights that union members have from at-will employees, because at-will employees can be terminated for any reason or no reason except for these reasons, while the union members, there has to be a serious reason. There has to be a just cause for their termination. Now, why is this distinction important? This distinction is important because in many termination cases, the employee who is being terminated can and should enforce both of these sets of rights separately. And here's a common example of where this distinction is useful and where it comes into play. Let's say you've been working for a company for 10 or 15 years and you've been a good employee, and then one day you were injured or you were diagnosed with a disability and you go on protected medical leave or disability leave, and shortly after you return you're being fired for a petty reason. Maybe you were fired for being 5 minutes late to your shift, and you have some other evidence of discrimination against you because of your medical condition or because of your medical leave. Maybe there is an email out there that says that your manager doesn't believe that you have a disability, or that he's unhappy about you taking leave. Or maybe you even have a witness who overheard a conversation between managers where they say how they would love to get rid of you because you're taking too much time off, or something discriminatory like that. In that situation, you can and you should pursue two types of actions separately. You can file a grievance with your union and work toward union arbitration because you were terminated without just cause. I can't imagine how being late 5 minutes to your shift could be a just cause for termination unless your job is so critical, maybe ER nurse or something like that, where 5 minutes is a serious violation. So this does not go to court. This is a grievance that goes to a union arbitrator. And at the same time, you can file a lawsuit in court for unlawful disability discrimination, maybe also retaliation, and wrongful termination. In many cases, pursuing both of these actions at the same time is a good idea for all kinds of legal and strategic reasons that your attorney should be able to explain you. What's important to remember is that these are separate and distinct claims because they enforce separate and distinct rights. The law has nothing to do with just cause termination. The law deals with protections against discrimination, retaliation, harassment, and so forth. The CBA grievance is a grievance for basically this contract violation, this bargaining agreement violation, where you've been terminated in violation of the agreement and not in violation of the law. Now, if you don't have any evidence of discrimination, let's say you didn't have any injury, let's say there's no evidence that you were treated badly because of your age, because of your race, because of your sexual orientation, but you were terminated for being a few minutes late, again, for a relatively petty reason, you might just be able to bring a grievance against your employer under the CBA because you were terminated without just cause, and then this stuff probably doesn't apply to you. And again, whether you have sufficient evidence to make a discrimination case or retaliation case in court is something your attorney can help you determine. But again, in many cases, you have this overlap. You have a petty reason for termination, and you have evidence of discrimination and retaliation, and both of these actions can be pursued. You don't have to wait till this is over in order to initiate this. You can do both of these things at the same time. They do not interfere with each other. In fact, both actions can kind of help each other in many cases. Thank you.